Yes, time's up. We'll continue with our second part of the meeting. Second item of the agenda. Now, according to 18th of July meeting, legal advisor had some comments or members had some comments. So, could the government respond to our questions? CB bracket 2 2146/1617 bracket 02. Is that clear? Are you referring to the letter dated 11th of July? No, it's government response. 17th of July, 18th of July, and there were some regulations on declaration of age and whether it was applicable to buyer and seller. Do you have the document dated 19th of September? You are talking about delivery. So let's deal with that. So on the last meeting, there was a question regarding whether the delivery person would also be liable, and our attempt at a response was that in the amendment. So for intoxicating liquor, we want to iterate that for face-to-face distribution, it is a defense for the person who in the course of business sells or supplies intoxicating liquor, but it does not include the delivery people or delivery agents. So that is our overall principle. So if the company is just responsible for delivery, they might not be aware what the goods are. So our legislation is directed at the supply. It will not affect them. Any other supplement? Any other follow-up from the legal advisor? So I think the question has been answered and there are no further questions. Well, if we don't have further questions, let's enter clause by clause scrutiny. So according to the Blue Bill Chinese version, CB bracket 3 658/161617. So we will conduct clause by clause scrutiny. Okay. So we'll start. So let's refer to CB bracket 2 1911/1617 bracket 02. So the amendment to Dutiable Commodities Ordinance Cap 109, we're making amendments. And in section 6 in the rules, it says that the chief executive in council may by regulation prescribe or provide for, and we are just targeting the sales to minors. That is in part P, and so regarding the prohibition on sales or regulating or restricting the sale or supply of liquor, we need to refer to Cap 109, Section 6, the regulation or restriction. That is Part OA.
the licensee would be have the liability. Our proposed amendment would be prohibit the sale of alcohol through vending machine. It's very difficult to regulate. As stop selling it to the underage. So the same, likewise for the tobacco. As we know that when they're doing inspection, we haven't seen vending machines selling alcohol. However, we are concerned that it will prohibit the sale supply to alcohols, and a vending machine would become another way to create a loophole. So we suggest for a complete prohibition of through vending machine instead of just targeting only minors, as it is very difficult to enforce the law. Clearly, there's some beverages a trace amount of alcohol. Does that mean we have to be zero alcohol content? We're only using the existing definition on the Dutiable Commodities bill, and the current definition of the licensed premises should not able to sell alcohol is only 1.2% of alcohol content as a standard, so we shall stick to that as well. So there's existing standard of 1.2%. Any comments for the legal advisor? None. Next. Move on to the amendments to the Dutiable Commodities Liquor Regulations, Cap 109 sub legislation B. So let's talk about 0005 in terms of the offenses and supplemental. Continue. So this is a city legislation B. On the fourth part, there's some modifying the wording. And currently, the regulations mention that those under 18 and underage and so on, in order to standardize the expression, and those that under 18 will be uniformly called minors. Just on paragraph 28 and 29, where such amendments took place. Mr. Paul Chair, because we're entering the class by class scrutiny, please continue. If not, legal advisor. Next, 0007. We have a new part 5 under 109B. This is a detailed elaboration on this amendment. Is a definition of some terms. Which first we talk about an agent. Does that include the one who deliver the liquor? Like I just said, we do not wish to target those who just deliver alcohol in the course of their business, whether individuals or corporations. However, how to make it explicitly clear, we will look into how this could be addressed. Of course, members have raised a similar inquiry earlier to whether we can make it even more explicit. So we plan to have some tweaking. We'll consult with the Department of Justice to see whether our existing definition is clear enough or there any room for improvement. So when would you offer a suggestion? That'll be pretty quick, actually. If there isn't any other questions, if it's only a clarification of definitions, that you will hope to exclude those only deliver liquor, so that those will not affect the unrelated parties. Comments from members or legal advisor? None? Okay. So please provide it to Let's Go afterwards. So you want to clarify the part on the delivery person. because we have a face-to-face distribution and remote distribution, and do we use agent is the best way to differentiate the two, or the way to make clear a separate wording to exclude the agent, because we want to target the sell and supply. You want to exclude the liability of this delivery person, so you need to make clear on that. So we'd like to propose a CSA. The best way probably would be as CSAs. So I shall wait for your submission, because we'd like to see if there are any other further suggestions to the amendments, and we'll deal with it all together. And on the definitions, as targeting for this amendment, the prescribed notice that according to law, you're not allowed to sell, supply alcohol, as well as the definition of face-to-face distribution, because would differentiate that, and if there are any face-to-face contact between the buyer and the supplier, so want to differentiate between remote distribution as well. Any other comments? So that'll be all in one sheet. So we move on to, so 39 is remote. Wait. 36. As I mentioned, I want to modify the main legislation, because in the regulation we propose the prohibition of selling intoxicating liquor from vending machines. This paragraph 36, the penalty would be a level 5 fine. Any questions? Mr. Paul said, back in 35, in terms of definition, so we talk about the agent includes for face-to-face distribution. So the other, we don't have any issues for other terms. How about the license and for the place? The definition of place. I don't know what stage are we in, because we don't have so few members. And Mr. Yun hope for more input to deal with it all together. I shall try my best. But I received notice that there's only probably not appropriate to a scrutiny with only one chairman, especially we're not using belt. Hopefully we probably need to stop and only the one present. There would be satisfactory arrangement, and even if it passed, there could be problems in future. So maybe I can ask more questions to wait for my other colleagues to join me. And for the definition, the place include a licensed premises. As for the licensed premises, does that mean one with a liquor license? This Cap 109 that describe a licensed premises, one that have a liquor license. So in this bill, the license had been a license referring to liquor license. Yeah, actually is stated in 109B. Mr. Ngwachi, for Dr. Paul's inquiry, in 109B, the subsidiary legislation had already defined a licensed premises. And currently, the one that venues that hold a licensed premises, we are using 109 as a blueprint, so we don't need to define. We don't need to define everything again. Yep. Yes. So for 36, if there are no questions, we move to 37. Selling or supplying intoxicating liquor to minors prohibited. And settle the penalty of a fine of level 5. And if we say that if a product is intoxicated as a gift, that will be seen as a sale or supply. Any questions? 38. Defenses for face-to-face distribution. The bill mentioned that the sale or supply of alcohol to under minors is prohibited, and if we've it's actually found to be the case, we mentioned what is the liabilities of the retail staff. So there's only two main aspects. If it's charged for the behavior, or if the person had inspected a proof of identity purporting to be the proof of identity of the purchaser or the recipient of the liquor, and reasonably satisfied himself because of inspection the purchase recipient was not a minor. So that would help for the retail staff. For any suspicion, to check the person's ID whether the person is a minor. So that would constitute a defense. Chairman, we'd like to backtrack a little, going back to 37, Action 3. And on the question of gift, back in the policy discussion, we bring this, for example, a letter with trace of alcohol in the chocolate. Now the 37.3 does not state the quantity. For example, there's some trace amount of alcohol in chocolate as a gift. So does that covered by 37.3? So the alcohol level or the percentage. For the existing legislation in 109B, and for Part 3 in Part 52, and the defined alcohol as for those of 1.2%. As for one of the ingredients, and this ingredient cannot be changed to ethanol, alcohol, or intoxicating, or so maybe containing alcohol. However, it's not easily to distill it into some alcohol to be consumed. That would not be covered, or not plan to target this. For example, the drunken dishes like drunken chicken, or the soft core molten chocolate core. Even though you don't plan to, or it should be targeted. However, in terms of wording, would that be a gray area? So if there are lack of a clear guide criteria, for example, it not be a major ingredients or state explicit percentage, that would not constitute or fall into the definition of alcohol. Ms. Ng, and 30.7.3, as what to say is that for this product is not the kind of alcohol we plan to regulate. Okay, let's an example. Is selling cigarettes and offer a bottle of wine as gift. And under this bill, the person will be seen as supplying alcohol. However, not for the same kind of food and have to have alcohol and other ingredients. Is not the case.
So you're saying you want to regulate the sale of something, and you also want to regulate the gift that is sold at the same time, that is provided together with the sales item. So when we deal with the legislation, they will say that it's a gift, it's not a item for sale, so there might be a loophole. So, but if the gift item is alcoholic item, that is also regulated. That's what we're trying to deal with. But Mr. Paul Jie was referring to liqueurs and the alcohol content alcohol content if it exceeds 1.2%? Is that regulated? So, legal advisor? Thank you, Chairman. We heard the legislator's question and the government had responded. So let's look at the wording and see if we can come up with a simple response. So regarding Mr. Tie's question, if we look at the Chinese version, let me read it out. To avoid doubt, if a person sells a product that is not intoxicating liquor, but that is accompanied by intoxicating liquor as a gift, the person supplies the liquor. So the wording, my understanding is that if they sell a certain product, as the government says, let's say they're selling a watch or something, and there is a gift accompanied, but it is an intoxicating liquor. So the gift, if it's to be covered by this legislation, it has to be an intoxicating liquor. And an intoxicating liquor in the principal legislation in Cap 109, there is a definition, and we have to refer to Part 3, Clause 53, interpretation, the definition for intoxicating liquor. It includes alcohol, liqueurs, grape, red wine, and other liquid wines. So if we look at this definition, if the gift, if it's a liqueur with alcohol, is it covered? Well, it seems that it is not covered. And if you require a supplement, I can do so at a later point. Any supplement from the government? No. So the chocolate, it could be a very large chocolate with a lot of alcohol content in it. Well, it's the same as the dutiable goods arrangement. We're not coming up with a new regime or a new system. Mr. Siokafe, you have a question? Well, just now we heard about rice wine. Is that a similar scenario? Well, the law covers that. So even for ceremonial purposes, we have to look at the alcohol content. It has to exceed 1.2%. Well, if that is the case, then even provision stores, not just the convenience stores, not just 7-Eleven, even the provision stores, you have to inform them as well. When we invited the industry on the last occasion, we had invited the provision stores. Okay, we'll continue. So we were dealing with Clause 38, defenses for face-to-face distribution. We were talking about frontline staff, and subclause 3, the store owner might also be liable, and his defense would be, did they take adequate procedures, whether his staff or subordinates during a business, in face-to-face distribution, did they sell intoxicating liquor to an underage person? So, did they provide training? Or in the store, were there any signs or guidelines? If that had been undertaken, that would be a defense for the store owner. So it might not be so important in our discussion. We now had a discussion about photocopies of ID cards and not being acceptable, and even an electronic version would not be acceptable. So in Clause 38, your defense, you need to provide proof of identity. So what would be acceptable? Does it have to be the ID card itself, the home entry permit or driver's license, other countries' passport, or a student ID? What would constitute proof of ID? Thank you for the question. So the proof of identity in page 0008, there is a definition. So according to Immigration Ordinance 17B bracket 1, Immigration Ordinance, that includes Hong Kong ID, travel documents, and Vietnamese people. I need to refer back to 17B. If you want more information, I'll have to read it out. Could you please read it out?
Sorry.
Which ordinance was that? 115. Chairman, proof of identity includes a valid ID card, a document issued by Immigration Department, a valid travel document, and a Vietnamese refugee ID. And valid travel documents also have a definition. That's under Cap 115. It needs a photo and so on. For example, when we talk about the passports, those are valid travel documents. So you can confirm that the Immigration Department will admit certain documents. What about the papers for... That is not included in the definition. The recognizance papers for the Southeast Asians. Well, if you want to use this defense and they request a proof of identity, well, that seems to be more stringent than the election committee requirement. So that you admit what I said is accurate. Well, when we refer to proof of identity, that might be a very loose term, but if you refer to the law, of course we have a strict definition, and we are referring to Immigration Ordinance, and so Hong Kong citizens would have a Hong Kong ID, so the ID could serve as proof of identity. Well, I don't see any objection to not using ID card. And we also have a definition for travel document. I think that is very clear. If we don't spell it out clearly, then which document should we make reference to? If there are too many options, it would be a burden to the person selling alcohol. They might come across a document that they are not familiar with, and if we are to draft the law, we need to make our requirements clear. I understand, but Hong Kong citizens are required to carry their ID card, but we have different scenarios. We might be able to use a driver's license or a home entry permit that can prove a person's age. Well, if you want to use this as a defense, you need to provide a Hong Kong ID. Well, I'm not trying to be a perfectionist, but if they want to use any reasonable defense, I think this is a reasonable request. I think that your attitude would be very arrogant if you, with previous response. So Are there any more? Are there other easier options or other arrangements? Well, I think we need to be able to spell out our requirements. And when we talked about a valid travel document, it does mention other requirements. So it's not just a Hong Kong ID card. Any other valid travel document, such as a passport, is acceptable. But from our perspective, we want to see whether we can make it clear, but we don't want to make it unclear or difficult for the users. There might be some disputes when we're not clear what the document is. So can the shopkeeper or the staff demonstrate that they had already checked the buyer's ID, whether they were 18 before they sold alcohol? So if we can make the document clear, it's a safeguard for both buyer and seller. But we can take on board Mr. Paul Jay's idea and see how we can make it clear and feasible. It is different from voting. If we can be clear on what is required, and if we can check Hong Kong ID, that would be clear. But if it's a different document, it might create difficulties. So by displaying a voting form, they might not be so familiar. So if we have different forms of documents, they would need to know how to handle the different requirements. So if we can use a familiar arrangement, it would be more convenient for everybody involved. But when we had a discussion with our legal draftsman, we specifically wanted to make it clear. Well, I would like to thank you for your response just now. It's more reasonable. So, since we are providing a defense, so it has to be made clear. If it weren't clear, the courts wouldn't accept that. So you should make it. You should relax a little bit. It shouldn't be even more stringent than a voting requirement. It should be more down to earth. We understand that a lot of scenarios might occur. People might have forgotten to bring their ID card, but they have a home entry permit. We just want to make it more convenient, so you could consider that. Yes, we do want to strike a balance. If it's too lax, it might be difficult for the person selling the alcohol. So the person providing the proof of identity also has a responsibility. They need to submit proof if it's a fake. If there's any problem, they would be liable. It shouldn't rest with the shop owner. So we can make it a bit lax. So the person requesting the proof of identity shouldn't be overburdened. As Chairman, you mentioned when they use a fake ID or other person's ID, that's a separate offense. So we need to remind the public that they should not use other people's ID to purchase alcohol, because that they would run afoul of a different offense. So the shop owners also need to be reminded. Our existing law already covers that. If I use a friend's ID or a fake ID, that is an offense already. Mr. J, any follow-up? No? Next.
Next, 39. The defense for remote distribution. It's similar. The only difference is that for remote distribution, because there's no face-to-face to check the proof of identity in person, so before the sale of alcohol, they need to receive a declaration by the purchaser that that he reached the 18 years of age, and if the seller and there's no circumstance cause to reason to suspect that the declaration was false, that would be constituted defense. And usually we're referring to the boss. Probably there will be as the alcohol will be sold by the staff, and it was charged because of another person's act, and it had taken reasonable measure to prevent intoxicating liquor from being sold or supplied by another person in the course of business in remote distribution. For example, a boss need to confirm that need to check that the website has such requirements, so that would be seen as a defense as well. Dr. Kwok-Kaki, that I found is problematic. So it is enacted that those under 18, it's quite difficult for them to buy at convenience stores. So for the websites, we made clear they only made to made a declaration that is 18% of age, and yet not able to provide any actual proof. And the online distributor or the merchant, and I think that there's no reason about that this declaration is false. So this bill could be nullified in effect. So as long as the person claimed that is overage and the seller claimed that he believed that person is overage, so how should we go with this? So even a young student would know that they would state that they were over 18, and the seller claimed that they don't know they're underage and I sell to them. So that would be one of my defense. And the owner would not get into any be charged. So you claim and set up an online store, and then as long as you claim so, then I would believe in you. So how do we enforce this regulation? A more reasonable approach would be, I'm quite worried this remote distribution thing, because this would create a very big loophole unless that the person to shows a copy of their proof of age or a document or the ID. You could buy at a convenience store and so on. However, Hong Kong is quite accessible unless it's far-flung locations, or let's say Iceland, and we need to travel great distance to buy alcohol. Then online shopping is more rational choice. And for the actual number of people who need to buy alcohol online in Hong Kong, the number is quite few, because they would buy through other means. Now that you create such a huge loophole, in the future, I wouldn't say on young children and anyone over 18 will resort to this channel. So how would you enforce this? Deputy Secretary, please. Thank you, Chairman. Thank you for Dr. Kwok's question. And online sale, the regulations will come to multiple considerations. We take reference with the practice of other countries, and our current approach will be similar to that of New Zealand's. In practice, to have an online store to prove that the purchaser is less of age is quite difficult. So how will we deal with this? That's why we have to strike a balance. So our current requirement that the purchaser will need to make a declaration that he's of age, and cap 200 and section 236 they'll be in breach of another offense if he is minor but claimed to be overage. We just state that if a person intend to make a false declaration or false statute declaration, a few such examples, they will be liable to imprisonment or a fine. If he's underage and claimed to be of legal age, it is possible for that one, if they were found, they could commit another offense, separate offense. But I want to know, how would you enforce this? And the whole purpose of this bill is to prevent the minors from buying alcohol. And now that you open the gates widely, there's nothing to plug this loophole unless there is a more stringent approach, or you actually do away with remote distribution altogether. Or there could be another way. Just an example, or hypothetical example. Or when you place an order, you can do so. However, for the pickup, you must pick up at the distributor had the responsibility of to inspect their identity. You must pick up in shops and physical shops and so on. Or when making delivery, I need to check your ID and so forth. This is additional safeguards. Otherwise, this bill will be as good as nil. And I will know that the best way to order would be through online. How do we offer more safeguards in enforcing the law? I hope to strike a balance. Maybe the Department of Health can explain afterwards, and can help to strike a balance so that we can able to effect enforcement without over-regulating. Respond. We feel that how do we plan to enforce in the future? So in the course of average selling alcohol, with deliveries made by the staff when they open the door, and notice the recipient is quite obvious that he's of underage, so he has the responsibility in asking for proof of identity, and it's therefore suspicion they should not hand over delivery to that recipient. Or maybe we receive a complaint that someone had delivered alcohol to someone under 18 and received by someone under 18, and upon receiving the complaints, the Department of Health will conduct an investigation, and we have sufficient proof. We need to look at both sides, and if the delivery person is aware that he's underage and without checking ID and still provide the order goods to him, and maybe the delivery person and the shop itself will be liable, and is a young children or someone who's under 18, and take the delivery and ordered by that person, and actually will be guilty of a false declaration. So in terms of enforcement of the remote distribution, this will the approach we plan to take. Chairman, I understand what you said. However, there's only two ways to enforce this. So either you enforce that the buyer would have the responsibility, or also the responsibility of the seller. And now that you have a very broad statutory defense, so where the problem lies in. So if the defense is quite narrowly defined, for example, if you sell alcohol to the person, so if you comply with the requirement ABCD, if you all failed to comply, you'll be charged if you breach that, and the sellers will then try their best to make sure that they will not sell the alcohol to minors. That's now they have such a broad defense. So for the seller, so because you claim that you are overaged, and the seller only needs to accept this. And how would the seller be charged? So no matter which age he actually is, so I still believe that he's of legal age. So this bill could effectively be useless. I'm asking about how do we enforce that? So if the law has stated that the seller need to carry out a series of steps to ensure that the buyer is of legal age. For example, on 5 steps, let's say when they place the order, need to have the proof of identity, or make sure delivery, and the person or authorize someone to accept the delivery, and upon arrival, the buyer will need to show the ID proof, or the seller will need to keep records of the orders so that they were able to check that whether all this the procedure have complied with in auditing. That will make the law to be enforceable and able to serve a deterrent as well. Now they have something as broad as this, and the buyer and seller need to be held responsible. And now the rules of the game is that as long as you say so, and I'll believe in you, that I don't have reasonable doubt that you're falsifying. So if the law be enacted like this, we'll all be finished. Deputy Secretary, do we have any overseas experience that we can take reference with? So as I'm worried using a New Zealand example, do we have any more stringent examples? Thank you, Chairman. Thank you, Dr. Kwok's question. There are more stringent approach elsewhere. For example, there'll be different requirements of making a purchase or taking delivery. We need to take a look at what is actually practicable in the use of proof of identity involved in personal information, and how do we deal with this? That will give rise to other issues. For example, let's say an identity card. It's quite possible there someone could buy on his behalf. So if he's determined to buy it, there could be a lot of ways online. The ordinance does not really create a huge loophole and ignore it. In terms of their personal behavior, I think they receive the age declaration, and in which there are no circumstances to cause the person reasonably suspect his declaration was false. So we can maybe upon delivery, you claim, and the person picking up delivery is obviously a minor. So upon delivery, you actually need to make a call to the person who placed the order to confirm that whether the buyer could be a minor. Otherwise, they could sell alcohol to minors by negligence, and the seller would need to take reasonable measures that the person had taken reasonable measures to prevent intoxicating liquor from being sold or supplied. So the Department of Health, upon taking the enforcement guidelines, still be detailing how it should be enforced. If the seller had not taken any measures, and once we found that we found selling alcohol to minors, so they need to have some criminal liability as well.
So we're not neglecting our duties. We have to look at the practicalities. So in clause 39 bracket 3, you mentioned reasonable measures. These reasonable measures are not available now. You don't have a text at this stage, so I am worried. If you want to persuade us that you do have a deterrent, then you need to spell out your reasonable measures. Otherwise, the sky's the limit. Have you asked? Have you examine the ID. I don't want to debate that with you. You've mentioned that whether will there be a registration system in the future? Will each order be which would each purchase record, each purchase order be recorded? Will each delivery be recorded? Who was the delivery person? You said the person delivering has to check the ID. Who delivered the batch of alcohol? Who took the order? Did the person who took the order conduct due diligence? If you don't have these records, they can just say, "Oh, I have a member of staff handling that." Is there any record arrangement for the person taking the orders and doing the delivery? Well, in the future, we will have a detailed guideline for the industry, and we will recommend the wine store owner or the industry to have a complete set of records. There's a declaration, the record, delivery records. So the legislation does not require these records now, but in the future, if we do discover an instance where they had sold to minors, the owner can use the records as a defense. If he doesn't have these records, he doesn't have the defense available. So we do suggest that the wine store owner have a complete set of sales records. Have you done any forecasts regarding the sales of alcohol through remote distribution or internet sales? I'm referring to the retail level, not wholesale. How much percentage does it make up? Does remote distribution make up? Do you have these figures? Not even customs. We don't have actual statistics, but we can look at Hong Kong Youth Survey. So for underage, for minors purchasing alcohol, more than 50% is done at bricks and mortar retail outlet. Well, I just want to tell you, it will become very prevalent because you have created a very large loophole. So, if I'm a wine seller, I'll tell people to not visit my shop. We don't need customers to patronize storefront. Well, we need to clarify this, whether this is a loophole or will it push sales onto the internet. We understand the concern. Overall speaking, we need to strike a balance in dealing with the issue. If we have to check a lot of procedures and if it involves a lot of manpower, we're trying to target alcohol sales to people under the age of 18. So how do we maintain adequate supervision? In our current legislation, we want to avoid such a loophole. Just now, Health Department responded. They would check the internet stores. So there should be a declaration on the website saying that they cannot sell to persons under the age of 18. But if they try to circumvent that and promote their sales, then the health department would target that behavior and conduct investigation. And we want our legislation to have a deterrent effect. So will that change the behavior of the minor? We need to step up education. Mr. Paul J. is in the queue. Well, it seems like we're backtracking, but as the deputations has stated, we want to take some measures, but you still haven't decided. We have a criminal legislation and allowing the government to fine-tune it. So the secretary you were reading, you were referring to a declaration. If we are dealing with the criminal legislation, we have very strict format requirements for criminal consequences. If you say that people can declare that they are above 18 on over the internet, you can just click agree. So how can you make sure that this is not a loophole? I agree with Dr. Kwok that you are now driving sales from bars to the street, and now from the street to the internet. You are not able to target you are not able to achieve your intentions. You are creating a lot of inconvenience to the public. We talked about what is a proof of identity, and now you require records and photocopies of sales to be used as a defense. So we're just talking about purchasing a bottle of wine, and you want the original ID, photocopy, and records. And for delivery people, you want records of checking their ID. This is very cumbersome. It seems like you're just plodding along and trying to fine-tune it as you proceed. But in the meantime, you're just driving sales onto the internet. And is this something that we should endorse and allow you to experiment with, Secretary? Thank you, Chairman. Thank you, Mr. Che. Well, I cannot agree that we're just plodding along and experimenting. We have made clear our intention and the defenses available. Dr. Kwok feels that it's insufficient, but Mr. Paultier feels that we're overdoing it. Our intention is to spell out our requirements, and just now you mentioned the criminal liability cap 200, where where people have made false declarations. That is clause 36 of cap 200. That is it's applicable even when an oath is not declared. Well, do you think 36A or C is applicable? 36C. B refers to accounts, balance sheets, inventory reports, and so on. So 36C refers to valid statutory verbal declarations or responses. But you're not talking about verbal. We're dealing with clicking on the internet. You're talking about C, not B. The internet declarations. It should be B and C. B is talking about other documents. Mr. Chair was talking about other documents, and C is the oral response or declaration, because when you purchase on the internet. It's a textual declaration, but so you can also place an order over the telephone, so an oral declaration is included. So these requirements, if it's to be amended in the future, will have to be done in the principal legislation. So if you're talking about the criminal liability, there is an ordinance and a penalty. So if from placing the order to sales arrangements and delivery, you have some basic requirements for that process, right? Will that be in the principal legislation or in the operation guidelines? We will have detailed guidelines for the industry to prevent sales of alcohol to people under 18. So we want the guidelines available for the industry. So we are worried that there is a loophole and it will drive sales onto the internet. So we would like you to tighten up the whole procedure. When we consulted the industry, they were also worried that whether they would have any omissions and break the law. So we would like the guidelines to be clear, how they can protect their own interests. So the guidelines will focus on internet sales. We want them to avoid any pitfalls, such as reasonable measures needed to avoid selling alcohol to underage persons. Well, I think we can stop here at clause 39 because time's up. So we do have some areas of concern, and you can provide a written response so we can continue on the next meeting. Next meeting, 1st of November, Wednesday at 8:30 in the morning. So, okay, please be punctual. Thank you, everybody.